She's actually hoping it breaks.
Oh,
no. All right, we're gonna go, oh, we are live, all right, well, there we go. Welcome back to the House Judiciary Committee. Continuing testimony regarding the pre-trial supervision program, we'll have Nick Vance join us. Thank you for being here. Thank you for being here.
Thank you for having me. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. Where would it best, what would be most helpful for the committee at this point?
I think hearing how pretrial supervision has been working, and where the challenges have been, and then we can talk a little bit about where we should go from here a little bit, because as Angela mentioned this morning, yesterday in discussing the accountability court, the 3B docket, became clear that maybe pretrial supervision as we have it set up now is not necessarily the most helpful. It sounded very helpful that DOC and probation is involved early on, and not necessarily with individuals in the program. But so it's a bigger picture, but also want to understand, we're trying to get to the point of making pretrial supervision useful, or so with all that, whatever you want to say, really. Yeah.
Okay.
But that's kind of the ultimate goal.
Sure. Well, just a reminder for committee members who are not on joint justice, who heard a lot of testimony throughout the summer and the fall. The pretrial supervision program is currently a pilot program. It started in Orleans, and then over the summer, when feedback came in that it was not many folks were engaging with it, or being referred to it, or being involved in it, the decision was made to move to Chittenden County, and then not at exactly the same time, but quickly thereafter, the accountability docket started to get formed. And the overlap of the 5 or more dockets, I think, kind of meshed those two together, but they weren't meant to be meshed together. It just kind of that Venn diagram meshed. So I think the big picture issue with pretrial supervision, the way it's designed right now, is that we all have to remember that this fits into our bail statute, our conditions of release, bail, pre-trial considerations. So if somebody comes in for arraignment on their charge and the court is deciding, for public safety, do we need certain conditions to be placed on this person, that they can't be in contact with someone, or can't drive a car, or can't drink? Like, what do we need to do for the next 6-12 months before this case is settled to keep the public safe if this person's out in the community? If this person is a flight risk, do we need to set bail to help ensure that they're here? And if so, at what cost, right? So that all still has to be considered. And I think that's the rub right now with pretrial supervision, that as written, to qualify, so to speak, for it to be considered for it, you have to either have a violation for a condition of release. So you're already out on conditions of release and you violated a condition. That's one pathway to being potentially part of this supervision, or you have 5 or more open dockets. And not exclusive, but most of those folks tend to fall into the misdemeanors, what we've been referring to as those repeat offenders on, quote, the lower level. Unless they're reaching the point where bail is being set for some reason, for many of those individuals, pretrial supervision is not going to be the least restrictive set of conditions to have them out in the community. So I think from the defense side, like, why would they want to agree to this? If they were potentially going to be detained or 24-hour curfew or something far more restrictive, then pretrial supervision may look interesting and be something that you need to agree to. So I think that sort of who we're trying to watch during pretrial supervision. And I think that watch, so to speak, is important, not to confuse pretrial services with pretrial supervision. The idea with pretrial supervision, my understanding is that Department of Corrections is involved and that there is essentially like a mini probation officer sort of filling that role of like keeping an eye on Representative Dolan and making, and if you agreed to go to certain meetings, that you're going to those meetings and reminding you that you have a court date next week, that connective tissue role. And I think right now, just who would fall into that? The current structure, most would not agree to that. And then those who would be, say, if I was arguing for someone to be detained with a hold without bail, and the court didn't want to hold them, but wanted them on sort of strict supervision in the community, as you heard from CSG, Department of Corrections does not have the resources right now to have that sort of supervision, right? You're not going to have a person that otherwise would be detained on phone monitoring. You would want them on electronic monitoring. And if the DOC was able to do that, then that would be something that would be of interest, I think, to both defense and the state. So I think that's the big issue of why it's not being utilized. I don't think we've quite found who we really are looking to supervise and then have it structured in a way that would funnel folks, like that it would be an advantage to someone to be part of the program.
So just to be clear, so the defense or defendant has to agree to be subject to the.
Well, they have to be order. I mean, it's an order from the court. But Defender General Valerio testified yesterday in House Corrections, and I know he'll be here. The defense is going to argue, again, per our bail statute, what's the least restrictive set of conditions? And so again, depending on the facts and circumstances in front of you, pretrial supervision is not going to be least restrictive for someone who would otherwise be out on a, don't contact Representative Rachelson in the court type of supervision, though they might need a lot of support, and everyone can see that, right? And that's a pretrial services piece. We might want to connect them with a whole lot, and we might all know, like, they're going to have trouble getting to court and remembering. And if we want to wrap around those folks, that's fine, but like, why would they want to be on pretrial supervision where, as Defender General said yesterday, they're pending their trial, they're presumed innocent at this point, and they're potentially setting themselves up for getting violations of conditions or release, right? If they have more conditions, more things that they need to do, potentially that's going to lead to more problems. Whereas with the accountability docket, those are all looking to resolve cases. That's why there was engagement from the defendants. They were resolving their cases, not being supervised, waiting for that case to resolve. And so there's a different level of engagement there.
So it's not necessarily just as simple as, well, let me back up. So right now, or looking back when we set this up, we were concerned about there being too many people going to pretrial supervision. So we set it at 5 dockets and somebody who's violated conditions of release or. So, and it ends up that there may be a couple up in Orange in that plan. There's only I thought yesterday was 3 or something like that in Chittenden County. So that's not the problem.
Yeah, I've not heard that they've been flooded.
Right, we're not being flooded. But is it, and I'm also hearing that it's not as simple as just lifting those restrictions and leaving it to much more to the discretion of the prosecutor, the defense counsel and court, that's not necessarily going to make it a more useful program.
Well, so there is one version of this bill that strikes out ECR in the 5 or more dockets. And we would agree, to leave it to just the consideration of poses a risk of non-appearance at court hearings, a risk of flight, or a risk of endangering the public. I don't think we need that 5 or more. I would agree with that. But I think it's just important to remember that, again, this program falls within the larger analysis that happens at arraignment. And so being able to think through how this supervision program within the conditions of release, who it would benefit, like who we would want in it, and then thinking through that, what's the plus for them, so to speak. And again, in my mind, it does, if it's the least restrictive of being detained, that makes perfect sense. But if it's for folks who otherwise wouldn't have this much supervision, there has to be, again, an argument for why the court can impose this, order it.
Yeah.
I'm just, I'm curious why, for specifically for the VCRs, like, so it's least restrictive, which but also reasonably will mitigate risk of flight, right? So for the VCRs, if you had a bunch of them, this isn't kind of like a release valve for people that they know that maybe the state's seeking more bail, trying to, like, we've had him on conditions, he's violating the conditions, violated conditions a bunch of times, and now we want, this much bail. The defense couldn't sort of be like, well, what if we had him on like this kind of supervision instead? I'm just kind of why that's not a way that or maybe is the way it's being used, and I'm just not understanding.
No, I think there's two things there. Yes, if somebody's accumulating cases, and depending on the cases, and again, for bail, it has to be a risk of flight.
Yeah.
So I could be violating my conditions of release, but showing up to court every time and I'm no risk of flight. So bail is not going to be, shouldn't be set the way our state is structured. But say I'm accumulating cases that now, my potential consequence is now starting to add up 5 years, 10 years, 15 years, then there's an argument for risk of flight that could be made. If bail could be ordered, that is when I think this program, this side of like, oh, don't set bail, I'm not going to be able to make it, but pretrial supervision, then I could see that's where that argument would make sense, and it would be the least restrictive. Otherwise, detaining someone who can't make bail.
Yeah. Right. So it could be how about the individuals who are just not showing up? And there's a good argument to hold them or to impose bail because they're not showing up, and that's part of the risk of flight. And instead, we'll do pretrial supervision where they'll help this person show up as part of it. Is that
possibly? But again, like failure to appear could be a factor in considering that, but it isn't an exact. You're a flight risk because you failed to appear. Like it's possible, again, depending on why they didn't appear. But yes, I think the point being, when you're teetering over to could bail be set, then pretrial supervision would be least restrictive if you're not being held on bail.
So perhaps one thing that can be done to make this a more useful program is to take away the current restrictions on who can go there and allow really the parties to figure that out in conjunction with the court. So that may be one positive step that we can do with this. It doesn't answer my kind of bigger question of where's the most beneficial place for DOC to appear. I mean, where and when should they show up to help out? And I think the accountability court suggests early, before, when somebody is pre-trial still, figuring out if it's going to be probation and what the treatment is and such. But that's not this. I don't think we can wedge that concept into this program. That might just be a matter of DOC having the resources to do that, maybe. I'm just kind of thinking out loud here.
Mm-hmm.
So one of the other recommendations by, I'm gonna find it right now, by CSG. Bear with me, I had it here a minute ago. Apologize. Well, it was having a more streamlined way for violations of conditions of someone who's being supervised, getting that before the court. And do you know that issue?
Yes.
Could you comment on how we might be able to approach that? If that really is a problem that we need to deal with, I guess is another way of looking at it.
Yes, we state attorneys, we disagree with CSG's recommendation. We understand it from sort of behavioral science perspective. You know, you want to have immediate reaction to someone. You know, you're going to have. That's of course fantastic. The issue is there's a few issues here. On pretrial supervision, it's part of your conditions of release, right? This whole program falls within your conditions of release. Those are court orders. If you don't follow those court orders, that can be charged as a crime. The probation officer, permanent corrections, we'll call supervising officer, so not confused with probation. Supervising officer for pretrial supervision cannot file a criminal charge. If the idea is, I think this is the suggestion, that essentially the supervising officer can go right to the court to say, Joe isn't showing up for treatment. And it's, as I think written in your draft, that the supervising officer could motion the court to change the conditions, or basically the check-in that they need to have more conditions or stricter conditions. I think that's the idea. You'll hear from other witnesses, but the court is not going to, I do not believe, in Vermont unilaterally, with the supervising officer's motion, change conditions of release. That was an order made with all parties present at the arraignment. We're going to all need to be present for that conversation. So even if the supervising officer filed something with the court, we still need to all get into court to discuss this. So I think the idea was that this would streamline things, move things faster. I don't believe that's going to have that impact. I think we're still going to need a court hearing, still going to need defense attorney, the defendant, state's attorney, prosecutor to be present, to have this discussion, to go back and forth on what is appropriate. So I still think it needs to go through the prosecutor, or at the very least, if they wish to file it with the court and the prosecutor at the same time. What they're filing is not a charge, it's information about how the person's doing on the conditions, but we don't think it's going to speed things up, which I think is what they were, CSG was suggesting.
Any other ideas on how to speed it up that would require changing the language in the statute?
The only universe, and again, other states have different structures where this works rather than us. If, again, because it was the least restrictive and the defendant agreed, and so this isn't just, I mean, it's an order from the court, but it's something that the defendant has agreed to be part of a program that has sort of a whole different set of rules, then maybe there's a different pathway where the court would be comfortable changing things without the parties present, but I have a hard time imagining that here, but you'll hear from the judiciary on that.
Right. No,
Just, I'm sorry, one other clarifying question is that, so if you currently in practice, like if you don't comply with your pretrial supervision conditions, is that just considered a VCR?
Well, again, There's sort of a small pool, so I
Yeah,
don't have
that's-
exact examples, but the
yeah.
idea would be, and the way the statute's written,
Yeah, I was just-
it's broken down into two, they say, let me just make sure, because now I've read like 3 different versions, but, so on page 4, and this is current law, pretrial, down on line 11.
Yeah.
There's court imposed program conditions. So those would be part of your conditions of release. And then on line 14,
Which document are you looking at again?
this is H529
Oh, okay, okay.
or bill, page 4. Then it says department imposed administrative conditions.
So the,
And the idea, like the example given there often is if there's a court order that you're on electronic monitoring as part of your pretrial supervision, but you charge your electric monitor.
Yeah.
That's a department imposed administrative condition, like keep your monitor charged,
yeah,
and sort of that distinction.
and so that would not be,
So that would not
be a
be a
violation of the court.
VCR, it theoretically.
yeah. I'm just thinking of ways, yeah, how to speed it. Like if it was always a VCR, then that would prompt maybe different conditions or request for bail.
Well, and here's the thing, like, we understand, like, it's not that these need to be VCRs, they don't need to be charges, but I think the idea that the supervising officer would communicate with the court, even if it's a department thing, and say, hey, we need to change this. It's hard to imagine that the court is gonna write back and be like, okay, without bringing in the defense attorney and the prosecutor to discuss, because essentially you're changing the conditions of the program. So, but again, you'll hear from the judiciary on that, but it's hard to imagine.
Yes, this may or may not be helpful, but I'm curious. Do you feel like this is a useful tool for us to be considering and looking at, knowing that we just talked about the accountability docket and like, seems like maybe we want to put our resources and attention in this, but then maybe I'm missing something. Maybe it makes sense to have this tool refined and available. But as I'm hearing this, I'm like, sounds like we're just trying to rework this completely. And we have this other tool that has proven that it works. So do you feel like this is a good investment?
I think it's wise to look at this and at the accountability docket resource wise, as far as this population of the sort of misdemeanor repeat offender folks, and see what is having the greater impact. Again, from our department's perspective, if this was a robust supervision of folks who are who we would consider higher risk in the community that we would otherwise want detained, and that this was of such a nature that they were being so supervised in the community that we felt that they did not, that detention wasn't necessary, that would be a more interesting conversation and a place of resources. But if it's working with the same folks who would be working in that other model, then I think that's a conversation of whether this is, because what we heard yesterday was that the accountability docket model was moving so quickly that we didn't need this supervision. Like nobody needed this because they're like, well, actually, I'm now already connected with services and I'm resolving my case in 2 weeks, so I don't need this. This, I think, when designed, right, was when the cases are taking 6 months, 12 months, 18 months, and we wanted to have that wraparound for those folks.
Okay, that's helpful. I feel like that gives decision points for us to consider, like,
Yeah.
where do we want to go?
Right. So I'm trying to, yeah, I'll get together in a second. I was thinking whether this was a program through which we could try to expand what was done in the accountability court. I don't think it is. I think that's a separate kind of conversation as far as DOC involvement very early on, like they were there, the whole team approach there. But is this a tool that could still be used in certain situations? Let's at least lift the restrictions That's one part. And then I guess if you're talking about this heightened level of supervision, is there something else that we need to do in here to empower DOC to have that heightened supervision? Or is the supervision sufficient that we have laid out in here for those higher level individuals? And if we're taking away those restrictions, and I don't know what the answer to that question is particularly. And do you have a view of whether you need to add layers of supervision if you're talking about somebody, like you mentioned, who could otherwise be held without bail?
No, I think the court has, I mean, through our current statute, the court would
So
be able
somebody-
to,
Could be sent to pretrial supervision in that scenario under the current statute, but
yes, I mean, with the exception of lifting the 5 or more docket or.
yeah, I'm just saying lifting
Yes.
those things.
Yeah, nothing would prevent being able to order that pretrial supervision, so the Department of Corrections is involved, and then all the other conditions that the court would want to impose to public safety.
Right. So the supervisor would have more to monitor in
Mhm.
that kind of situation, but, all right, Andrew.
I think the way that I'm trying to think about this is that, and I wonder if you sort of just said this, I want to make sure that I'm understanding correctly, but I would like to avoid duplicative services, systems, programs, what have you. And we don't want to leave gaps. So in thinking about this, though, something you said just helped me frame it a little better in my mind, that I also want us to be thinking about what we actually want. And if what we actually want is for cases to be resolved faster, then we're looking at more something along the lines of the accountability docket and how that process worked. I think that's what we actually want. And it's feeling more and more to me like pretrial services, and this is where my question comes in, was kind of like a Band-Aid because we weren't resolving cases fast enough. So I just want to understand from your perspective, is that not true? Is would it be fair to say that there is a need for this type of supervision done well for a certain percentage of the population who won't qualify for any sort of expedited process that we maintain?
Well, I think there's two things. This pilot program currently and the accountability docket was a short-term pilot program.
Okay, so given that,
Right, so that's what
it's like choose your own adventure. So like, which way should we go?
You're not gonna get an answer.
I would look at them as both tools and how we are approaching this, and I think that this might fit certain individuals. The question is, and this is more for DOC and the administration, is this where they want to put their resources? Is having 6 supervisors or whatever number around the state when there's only a half a dozen people who actually fit in this, does that make sense? So that's, I think, almost a resource issue. Or do they want to put that money towards having probation officers at the courthouse pre-trial? And so I think it's almost this is a tool, but where do you want to put your resources and money?
Right, and so I guess I'm asked from the essay's point of view, like, what do you want us to do?
well,
That's a good question.
I want you to do all sorts of things, but
We're at
I think that
point, so like, use your imagination, feel free.
build Kim's world.
Visioning, we're visioning.
So, well, I think it's important, and I was not here in 2024, but I've heard a lot about how this pretrial supervision kind of came into being and the criteria that was put around it, that was all sort of the end of the session. And I think this is a great moment that the landscape has changed a bit. We do have some interesting data from the fall. And I think it is a really great time to step back and say the big question of who I think there is a role for an idea of because right now nobody's supervised. If you're out on conditions of release, you're not being supervised. You're expected to come to court and not do bad things in between, right? And nobody's checking in on you. And there are individuals who could greatly use that. But they're, in my mind, two very different populations. There's the folks who are the repeat offenders who have a whole host of issues, and we'll just put it under like the umbrella of executive functioning that could really use that scaffolding around them. And that makes tremendous amount of sense. And if there isn't a sort of rapid way to deal with their case, that makes a great sense to keep something like this for that case that's 6 months, 12 months out. That's one population. The other population, who kind of have all sorts of host of issues as well, are the folks who, from the state's perspective, we would deem highly dangerous for the public and are right on that edge of like, should they be detained pre-trial or could they be in the community? And I can think of a perfect example. I had a aggravated domestic assault. It was actually charged as an attempted murder. Person fired 2 shots into the car of his ex-wife while she was in the car. And I argued for a hold without bail. And it was a very long argument, a lot of back and forth. And then the judge did a very nuanced, surgical carving to create conditions of release so that the person could be out, but as restrictive as possible. If there had been a pretrial supervision with electric monitoring, I would have asked for that. If we weren't going to hold the person, I would have wanted a whole lot of restrictions. What that person did have was, it was a curfew, but for work. Couldn't go to certain areas of the county. Like had a responsible adult who we had to phone check in with twice a day. Like it was almost like having a supervising officer, except it was a family member. So in my mind, yes, there is a place for pretrial supervision, but we really need to take this moment to think about who and then how DOC could resource that, because those are very different resources, right? Being the connective tissue and the check-in person and providing the connection to services versus regular check-ins as far as like physically, like where are you, and monitoring someone's electronic monitor, like very different. But I do think this is a wonderful time to discuss this and to think about the resources.
Right. So what I'm at least hearing is remove the restrictions. So there's more discretion on who can go there. And we obviously have more discussions that we have to have with DOC and others. And we'll hear from Matt Valerio as well at his points.
And yes, and just to drive home, don't go around the prosecutor to talk to the court. That's where we're opposed to that.
I forgot that message as well. And I appreciate it. Thank you very much. I'll turn to Judge Soman. Thank you for being here, Judge.
My pleasure. Thank you. Tom Zone, Chief Superior Judge. I will ask Representative Goslin, what am I about to say?
Policy decision.
Right. You keep asking the big question. Is this something we should pursue? Is it something we should look at differently? We've had it in place, and it was a pilot up in the Orleans courts. How often was it used? Twice. We've had it as part of the pilot docket. How often was it used?
I think 3 times. Oh.
The trend is on the way up.
33%.
Out of how many cases then?
There's 100 and some people.
Quite a few.
Okay.
So I say that because the idea of supervision, if we look at the federal government model and the criminal justice system, they have pretrial supervision. They have less people, more resources for doing it. And this was when this bill came up. This is my position was it's a policy decision, but if you're trying to create a federal model, this isn't it. This is something, it seems like the goal was to get people resources and to have, in my recollection, the testimony downstairs and here was, we want to have the probation officers be able to assist people who can't help themselves getting into the treatment, identifying locations and identifying treatment.
And getting into court.
And getting to court too. Reminders. Interestingly enough, what does that sound like? The pilot docket. And so what we know is that when people have someone who's going to help them get resources, who is going to maybe give them reminders, or we set it at a date where they're going to know show up on Thursday, every Thursday, whatever it may be, we know that that effectuates part of the goal here of what the pretrial supervision program is. And that is to help people get the assistance they need to better their lives and reduce recidivism. It doesn't give you supervision because we don't have anyone supervising. Years ago, what would happen in some communities, the Rutland police would, or state police would sometimes go out. They'd look on the wall, I guess, see who had conditions and who had curfews, and they'd go start knocking on doors. And that was pretty good because it was unexpected. And it did make a difference. And so having someone there who has the ability to check on and monitor, there is a benefit to that. And so that aspect of this does have a purpose. But the lack of utilization and the recognition that we now have from the treatment docket, I'm sorry, the pilot docket, that's a policy question for the legislature is, look, we haven't used it, but boy, if we put the money here, we have resources that people are using. We've moved through several hundreds of dockets, a number of individuals who early reports are coming back saying that the individuals have benefited from that. And the community has benefited from that. And so, when you're asking the big question, where's the money better spent? That's a policy decision, but when you look at the data, it's tough to decide in some ways because one project was never used. And does that give you your answer? Possibly that why wasn't it used? Nobody bought onto it. Same as home detention. We keep seeing that. The numbers are always hovering 5 or 6. And there's nuances to home detention as to why that's not used. Oftentimes when someone files for it, the parties resolve the cases. So it's not always the same 5 or 6 people. But I point that out because there may be a very good reason to have this program because there's nothing else that can replicate it. In other words, if there's no one else who can supervise, you would need something like this to provide the supervision if that's what you're looking for. But if all you're looking for is someone to help identify resources, help people find the resources, show up for court, give reminders, the pilot docket showed that there's a different way to do it.
That doesn't necessarily have to be part of the program. That's just where the resources, I mean, we don't have to legislate that.
No, you don't have to legislate. Well, you have to legislate
to get the resources.
Exactly. You have to legislate the resources somehow because when we look at these programs and we look at the resources we need, yes, we have pilot dockets and we're going to try to expand them. But I think, as I said yesterday, this is what every case should have. Everyone coming into our courts, whether you're on your first charge or your 5th or your 10th, should have the availability of resources so that we can help you move ahead and get the help you need. We don't want the people on day one to come back with 5 charges someday. The goal is to resolve that case in a timely manner, in an appropriate manner, and not have them come back. That enhances their lives and public safety.
So do you think the restrictions that we have for who can be placed in the program is playing a big role? I mean, if we eliminated that and left it more to the discretion of prosecutor's defense and the court, that maybe this would be used more? I mean, should the pilot extend with that out?
If you're going to open up the pool of who can be in, I would think that there is a greater chance of it expanding. But the question is it going to expand? I have a crystal ball, but what I think we heard a bit ago was that timing. Why would somebody want to go into this program if they're going to resolve the case quicker? And again, isn't the idea to resolve the cases? And so does the program bring with it the potential for actually extending something that would have possibly been resolved sooner. And that's a potential. But again, there's a balance that the legislature has to decide on, and that is, do we really need someone, DOC, to be helping with the resources? And if we do need them to be helping with the resources, do we also need them to be out monitoring? And if the answer is yes, then the next question is this the way that needs to be structured? Could you, for instance, take the resource piece, and what did we know about DOC? What we heard, I believe, yesterday, and I didn't hear a testimony today from people about what DOC's been doing, but DOC was an integral part of the pilot docket. DOC was at the table helping. And I think it was Zach Way who said, when you had this, and it might have been at a meeting, so he might not have said this in the committee, but when you had DOC there, in the old days, what would happen is you'd say, well, okay, let's do this plea, and well, what's going to happen? Well, I'm doing X, Y, and Z for treatment. And your attorney would look at you, and the state's attorney would say, well, we're not sure if DOC is going to let you keep doing that. It might have to go to a different treatment provider. We don't know if they're qualified, accepted, whatever it may be. But DOC was at the table in Chittenden, and they were able to say, okay, we'll take it from here. We're going to continue and keep that momentum going. And so DOC, does it have to look like this for DOC to have that involvement? In Rutland, DOC used to walk next door and basically have one officer sitting. I mean, this is in other courts, this happens too. And they have one officer sitting there who served as that liaison. And they would say, hey, can you check? And they would go and check. And if someone doesn't show up, they would go and make a phone call and say, have you heard from this person lately? Things like that. It worked. And it didn't require this type of structure. It required the communication and the time and the resources. And the question about having supervision, does the person who helps with the resources have to be the supervisor? That's a question for you to decide too. Could DOC have individuals who work for them who, structured throughout the state, their job is to monitor conditions of release. They just, okay, here's people who we're concerned about. They come over from the court or a state's attorney or someone highlights them, and they go out and say, okay, we're going to go check on these conditions for people. Could that be, is there a law enforcement function for that? So I think that the real challenge for the legislature is you have a process in place that hasn't really been used. Do you try to keep tinkering with it to say, well, we're going to do this, we're going to do that? Is that going to fix why it wasn't used? And now you have a pilot docket that shows things that do work and have been used, and you have to make those tough decisions as to which direction to go in. And I look forward to your answer.
So I think, we really need to have further discussions with the Department of Corrections and the administration. There are two roles here, the liaison to the prosecutor defense in the pretrial and that what works so well in the accountability docket, or the DOC monitoring of conditions, or somebody monitoring. Those seem to be two separate things, and I think we really need to get guidance more so from the administration. You see,
And they're both very important aspects of our criminal justice system. And the question is, again, is what was put together, has experience now taught us that maybe there's a different way to look at it that might break things up? And I think the pilot docket was something that, I won't say threw a monkey wrench in, but I think it really highlighted that if we can get the resources to people and get them moving on and have DOC at the table helping out, we're going to get more timely and better results.
so we have more testimony we need to take and try to figure this out. So thank you very much.
Thank you.
Do you have any questions though for?
Jeff, I have a question for you.
Okay. Go ahead.
And I apologize if you already shared this, but so this bill is in corrections.
So I'm not really calling this a thing. There's like.
We keep referring to a bill.
Yeah, well, I did refer to the bill that we actually have in here. There's also corrections is working on a committee bill, and in H721, the administration bill, there's also some provisions in there And all of that was done in part based on CSG's recommendations and before the lessons from the pilot. So we're at a different place now than any of those three bills, in my view. And it's kind of a bigger discussion. I mean, the one thing I think is if we are going to move ahead and keep pretrial supervision on the books, that we lift the restrictions and that's all that we do to it. But then it's really DOC deciding where they want to put their resources. Do they want to put the resources in for a liaison, which seemed to work very well? I don't know that we need to legislate that, but that's further discussion. Or do they want to put money towards having some supervisors under this? I think it's a conversation among us,
We're gonna coordinate to have, so I just don't want us to have competing.
No,
Bills or-
no, I will be talking to Chair Evans.
That's the bill.
We are
Okay.
not landing yet, but we're our discussion.
I'm appearing there at noon
All right.
On the same topic.
on their committee bill. Yes, this topic, what would you like me to tell them?
You can share what we said, we're getting rid of it.
I won't tell anybody. We're not being live streamed. No one will know.
Able.
And to get work through on this.
And yeah, don't work for
Yeah.
We're actually having a meeting next week on that.
Yeah.
It's the state's attorney's involved in the
Right.
meeting?
Yeah.
Okay, excellent, excellent, thank you. Thank you very much. So we are adjourned until 1 o'clock.
Oh.
Oh,
And you're back.